Good afternoon to those of you on the East Coast, and good morning to those of you on the West Coast. And I'd like to thank everyone for joining today's webinar, The Pro Se Playbook, How Unprecedented Plaintiffs and Pre-Litigation Demands Are Reshaping the TCPA Landscape. I am honored and humbled to present today with my colleague, Rebecca Klar. As most of you know who have previously listened to our webinars or attended our in-person conferences, we typically put together these webinars as a result of the interest raised by some of our clients and constituents. And the specific subject matter discussed today is one that's on everyone's mind. About 2 years ago, we did a webinar about the rise of TCPA litigation, which now has risen into more than litigation itself, but perhaps mainly driven by those who are looking to monetize their claims without the use of counsel. And as such, I think it's a perfect opportunity to discuss what's happening in the pro se pre-litigation space. When I use the word pro se, obviously it's a very legal term, which basically says it's someone who will represent himself or herself. But in this case, I'm going to be using it intermittently, specifically referring to those who are just not represented by counsel. A little bit about myself. I am a regulatory attorney. I represent companies in different financial services areas. My companies range from fintechs, banks, technology companies to those in the debt relief space, which include our servicers or backends, front ends, payment processors, and various different vendors. Of course, I always mention that one of my biggest passions is being a regulatory attorney actually in the cryptocurrency space. I teach in that space. This is my ninth year teaching at Hofstra Law. And 2 years ago, I published a casebook, which is now being used by numerous law schools throughout the country. I'm going to turn over to my colleague, Rebecca, to introduce herself.
Yes, hi everyone. Thanks so much for having me today, Felix. Like Felix said, my name is Rebecca, and we work together on these TCPA cases. A little bit of my background is I've got just about 20 years now of litigation experience, and so that has brought me through every aspect of the court process. Sometimes it's just a demand letter that doesn't proceed into court. Sometimes it's all the way through arbitration, settlement, trial, whatever type of resolution eventually occurs. So throughout the years, that's given me a lot of experience in how to handle litigants in all different types of capacities, whether they're pro se or represented by counsel, and some serially predictable counsel, as we're going to get into in some of the presentation today. My career is always centered mostly on commercial civil type disputes, and so this has been my arena for a long time.
Thanks, Rebecca. We're actually very lucky to have Rebecca. She joined a growing list of attorneys, and we've, in the past, I would say, 6 months, have grown a number of attorneys to join our litigation team. And thank you, Rebecca, for joining us at this webinar.
Absolutely. Thanks for having
Uh,
me.
Absolutely. So, first and foremost, I would like to, as always, note it's that time of the year when we begin to promote our upcoming regulatory workshop, which will take place in Irvine, California from January 26th to 27th. This is a sixth regulatory workshop. We've had tremendous success from the last 6 years. The number of patrons attending a regulatory workshop has grown. It's really a great event for you not just to know a little bit more about the debt relief industry, and particularly the regulatory side, but meet and network with some of the stakeholders. You can register for the event directly from our website, which is shipkevich.com. The attendance is only $150. It's not expensive considering, and includes food and drinks. And I believe we have another month for the discounted hotel rate at the Irvine Marriott. So if you didn't register yet, please do so. The registration is going pretty quickly. Last year, we actually were oversold. Actually, last 2 years were oversold. So hence why we had to go to a larger venue. And of course, we're extremely grateful for our executive level sponsors and support level sponsors. Our firm does not generate revenue from this event. It's for educational purposes only, and we are very grateful for CFTPA, Global, Veritas, Legal Plan, Reliant, Fourth, and AmeriCorps for generously sponsoring the open, the closed reception, breakfast, and lunch. Without the executive level sponsors, we would not be able to put together these events, and we are very grateful for their support. It really means a lot to us. We also are very grateful for our support level sponsors, Credit, Max Decisions, Consumer Defense Partners, Clarity, IPDA, Lending USA, and Cordoba Legal Group. We the sale, the ticket sale proceeds all go to not-for-profit, which our firm has supported for now. I believe this is our third year that we donate all of our ticket sales proceeds to the Women of Debt Relief. And we are extremely grateful to the Board of Women Debt Relief and to Teresa Dotson specifically. So without further ado, let's get into the topics of discussions. So first, we'll talk about what's causing the rise of pro se TCPA claims, how online communities, templates, and AI have simplified the creation of demand letters, why claimants choose to file pro se, and they try to avoid paying attorney fees. And yeah, they really treat some of these demands as a side hustle, and we'll get a little bit more into that as we go through our presentation. We're beginning to see common patterns and warning signs, such as template-driven demands, inflated damages. And it's interesting how the inflated damages are, you could see the pattern amongst the different type of demands, misapplied statutes, and threat style tactics. My favorite one is when they basically say, if you don't pay me money, we're going to hire a lawyer. And, and obviously telling a lawyer that someone else is going to hire a lawyer really doesn't really do much for us, So we also want to talk about something that is very troubling and should really be addressed by the consumer financial services community, by the debt relief industry, and also other industries who are dealing with these questionably legal demands. It's because we've found evidence of ghostwriting. We'll talk about some of the examples, coordinated groups, and that's right, there are coordinated groups that coordinate, demanding money, and then some subsequently suing companies, and of course, repeat filer tactics. For those who are lawyers, you'll definitely appreciate our discussion about the ethical consideration and prohibition surrounding ghostwritten filings. And at the end of the presentation, we were going to leave the best for last, which is what can you do? How can you defend? And we'll discuss the defense strategies with these pro se claimants. Okay, so really quickly, I don't think we need to spend more than 30 seconds on this. Obviously, TCPA has been around since 1991, and TCPA was created in order to provide someone the right private cause of action, state small claims court, right? For those of you who've been to our webinars, know that I like to start with the historic part of any statute, right? So TCPA was never meant to be, well, initially was not intended to be one that would be litigated in as class actions, and certainly wasn't one where these pro se claimants would now use it as their ways to do a side hustle. But really, it's more kind of to go after companies and small claims court. But of course, by 2015, the TCPA volume has ballooned, and I think we could be cynical about the 2015 being the balloon time. It's just in comparison to 1991 as balloon. But if we looked at 10 years later, that balloon has grown by multiples. And now we have, statutory damages that could be up to $1,500 per call. And I just want to obviously underline and highlight the up to $1,500 per call, because a lot of these pro se claimants really think everything entitles them to maximum penalty. Um, TCPA remains one of the top consumer protection statutes in our country, in terms of filing of claims in courts. And for those of you who follow debtreliefwatch.com, our firm's newsletter, every month we publish a report. We publish referring to WebRecon's report, the statistics, and we're very grateful for WebRecon for putting together the figures of tracking the TCPA actions by different states, and also the class actions where they're focused in which jurisdictions. Now, more than half of the top serial TCPA, believe it or not, and this is taken directly from last year's article issued by the U.S. Chamber of Institute for Legal Reform, more than half of these TCPA plaintiffs are pro se or semi-pro se, and I put the quotation marks because obviously if you're pro se and you don't have any legal education or legal background, but the type of pleadings that you sign, that you file, or the type of demands that you send sound very legalese, that there's a pretty reasonable expectation that someone is helping you behind the scene. Now, this is from that very same report. This is not our firm's report, so you could see that we cite to it from April 2024. It's a little bit outdated, but it's probably the closest one that we found by a reputable data source, which is ILR. And you could see some of the names of individuals who, typically file pro se. Some of them use law firms and some of them file pro se. We're not going to go through these names, but I think you could probably spot a few names that sound familiar. And interestingly enough, some of these individuals, at least our firm has dealt with on a repeated basis, and they continue to file these pro se lawsuits. Now, of course, pro se litigation and serial pro se plaintiffs have long existed, right? It's not a new occurrence. But what we've seen, right, is a pretty material rise in coordination and sophistication. And I mean it sincerely. One of the counterclaims that Rebecca will talk about this and down the presentation will be the fact that there's an allegation made in a recent case that these pro se plaintiffs, in fact, allegedly, I'm emphasizing the word allegedly because it hasn't proven, but there's an allegation made by one of the defendants in bringing the counterclaims that they coordinate that these pro se plaintiffs coordinate with each other, go as far as even creating allegedly, they incorporate their vehicles and they share data and information. So it is for some of them, and for those of you who obviously have dealt with some of these serial plaintiffs or claimants, it's more than a side hustle. Some of them make pretty decent amount of money prosecuting companies. And of course, thanks to AI, which we probably should also mention is one of the main contributing factors, we're seeing more and more mass-produced litigation demands from pro se individuals, right? And this actually, we took it from an article written by a firm. We're seeing fewer first move federal filings and more direct demands of informal claim letters. Typically, most of them are in the form of sending an email rather than your standard letter via U.S. Postal Service. And these letters are designed to essentially trigger quick confidential settlement rather than to litigate the merits. And I'll provide you with a couple of sample ones that we've seen shortly. Um, Here's what we see then. We see in these pro se claimant pre-litigation demand letters, right? So now we're focusing on pre-litigation demands, right? They're copy-paste statutory language and provide minimal case-specific facts. In fact, I could tell you the more they go into case law and any analysis of case law, the more likely there's an attorney that is ghostwriting behind that demand. But the copy and paste of statutory language is, arguably very much resemble most of these pro se claimants and sometimes even identical. Um, we also, I guess enjoy reading the overstated damages, 500 to 1500 per call. You almost assume that immediately someone's going to pay them from 500 to $1,500 per call. Some of them allege DNC violation of the not call rules, but they never even provide any DNC registration, and you sort of have to ask them if they even have one, and some don't. Um, One of my favorite also is the fact when they misspell federal statutes. Actually, the TCPA, like here's a good example. That's not a correct citation. Um, with the recent enactment of the Texas mini TCPA, now we're seeing a lot of there's a lot of focus on many of these pro se claimants are based in Texas, and not necessarily always in Texas, but we see a significant trend coming from Texas, and we see citation to the Texas mini TCPA, though quite often they cite not the incorrect statutory violations and those that are reserved specifically for regulators. Um, these demands also include screenshots of call logs, threads, and occasionally CCFTC complaints, or sometimes even I would get like screenshots of BBB complaints against the client. Yet, I would probably say that in 95% of the time, there's no direct linkage to the alleged violation of by the entity that where they're seeking these monies. And I'll show you in a few minutes, but basically, they'll send an email with a bunch of screenshots from their phone, but there's no reference to the company. I mean, I wouldn't be surprised, and I assume that they probably recycle the same phone number and the same screenshot to many different companies where they send to see which one will ultimately pay them. Um, and at the bottom of these emails, it's usually payment is due, right? It's almost like an automatic presumption of guilt or violation of the statute. And then if you don't send me money, the lawsuit will be filed. So that's typically what goes into them. Here's a redacted one from a year ago. This is a very typical demand. Some of them are shorter. This is more on the lengthier side. Now, the reason I included this one specifically is because just to basically show that they're obviously it's a pretty lengthy email. Two, it was probably written with the help of an attorney. I'm going to assume that it was written with the help of an attorney. It's pretty well written. And three, it's a pretty standard format when they basically just will indicate the date of either the voicemail or the text message or the phone call. So that's one example. Obviously, we could include a myriad of examples, but here's another one that was pretty recent. Here, this looks like a ransom note because if you actually pay attention closely, you see different fonts being used, right? You could actually see that the reference to the Texas Business and Commerce Code was somehow pasted in the middle of all this. Anyway, just a couple of examples of what these look like, and A lot of times they don't even, sometimes they'll include screenshots, and sometimes they don't even bother. They'll just basically say, I'm entitled to $40,000, but my settlement loan for this 25. I mean, that's kind of just immediately they think that someone's going to write them a check for $25,000. Anyway, where do they all come from? Where do they get this information? Well, well, here's an interesting one. You can go to Reddit. Reddit has a number of groups, and here are just the two examples that will provide the public with an opportunity to basically, you know, get free information of what to do, where to get these templates. Some of them provide these templates. Some of the individuals on Reddit will, discuss how much money they were able to, and I'll put in quotation marks, extort from either a defendant in litigation or pre-litigation. Some really gloat about it. If you're really bored one night and you have difficulty falling asleep, I really encourage you to go. It's quite a fascinating rabbit hole to go down. Some of these Reddit, um, I guess you could say posts or rooms, um, you know, not just provide you with templates, but interestingly enough, even refer you to attorneys. I've seen that. They will tell you to contact, and obviously, it wouldn't be the pro se plaintiff or claimant. It's obviously one of these organized groups that profit from it. And they'll say, well, we'll sell you these templates for a fee, or we'll tell you, hire us as consultants, and you're going to make a lot of money. It almost like sounds to me like an infomercial that you typically see on television. Except for in the form of a Reddit post. Um, Here's a few other examples. On Etsy, you can buy TCPA demand letter and call log kit or stop robocalls template pack. And the favorite one is it's attorney written for pro se users. Um, Probably is written by an attorney who's just trying to profit from it, and probably not probably, but very likely doing it in violation of professional ethics rules of that state, because there are significant limitations and really prohibitions on ghostwriting. Hey, and of course, there are those who say just ask ChatGPT to draft your demand letter. And we've seen ChatGPT drafted demand letters where recently I saw one where the person literally copied and pasted and forgot to include that, when I don't know what you would call it, but reference from ChatGPT. How do you like this response, or how do you like this template? They would really, I mean, they wouldn't even bother to take that off. There are also websites that offer assistance. Here's a couple that we found. Claim.pro, and they allegedly offer AI-powered complaint generators for TCPA filings and creating demand letters, federal complaints for pro se litigants. Um, Look, I've been a member of the New York bar since 2020, 2003, I believe, 2004. No, Connecticut was 2003, New York was 2004. And I could tell you that in the state of New York, you can't, at least under the professional responsibility of my state, you can't draft anything that would be filed with the court for pro se litigants. There are some exceptions for like legal aid, for instance, or these not-for-profits that can assist individuals. And again, that's done under the supervision of an attorney, and there's some accountability for that. Websites like Legal Husk and Caling.io, also a couple of other examples where they sell books or pamphlets, or whatever you want to call it. Obviously, these are self-published materials, not published by Random House, or anybody legitimate. It's navigating telemarketing violation claims pro se litigants and how to sue telemarketing. So anyway, there are many websites that try to show you how to do it yourself and play a lawyer. So what are the economics? Why why are these Reddit posts? Why are people trying to monetize it? It's interesting, right? So there are those who are trying to monetize it by sending pro se demand letters. And then, of course, there are those who are trying to profit of those people who are looking to get into the game. Well, if you can prove that someone is liable, it's $500 to $1,500 statutory damage, right? And so it's not exactly minimum wage amount, and that's per violation. Um, so if you look at some of these serial claimants, if they do 5 to 10 settlements and, you know, 5 to 10 grand a pop, I'm just hypothetically, that's a decent amount of money. That's an annual salary for some people. And Yeah, look, it's really kind of your side hustle mentality, right? You're doing this under the premise that you're trying to uh, use our consumer protection laws to prevent and curtail any type of abuse of telemarketing laws. But at the same time, it's also kind of cute when these individuals try to make a side hustle without really providing any evidence and doing so um, just for the sake of making a quick buck versus using these properly. So I'm going to now turn it over to my colleague, Rebecca.
Sure.
Oh,
So,
wait, is this still mine? I apologize, Rebecca. Uh,
oh, no, go ahead.
yeah, sorry. One more slide. I apologize. I forgot.
Sure.
Um, That's what happens when you have a long day. So um, these, of course, like I said earlier, there are a lot of fast payout incentives to these individuals. They try to these manufacture litigation, yeah, easy buck, right? You try to send out 50 emails and see who bites, and yeah, they tried to skip the court entirely. And let me give you a very good example, actually, before I turn it over to Rebecca. Well, there's a big question is why do we see a big rise in these pro se demands versus court filings? So, well, some of the leading attorneys in the space, the plaintiffs' attorneys, are charging very high fees. I've seen fees that are very questionable. They're in excess of 75 to 80%, right? So if a case gets settled and the client gets a few $1,000 and the attorney keeps most of it, um, well, that gives you the incentive to not use a lawyer and try to get this all yourself. Of course, you're probably asking yourself, how is it possible that somebody would be able to keep that much money for providing legal services? That's a different question, and it's not for this webinar. But that's what really is giving rise to some of these. There's a huge fast payout incentives. You don't have to wait for a lawyer to collect the fees or file a lawsuit. So,
Okay. So, I mean, Felix is exactly right. We're seeing so many more of these pro se litigants, and I'm sure you are too. And the reason it seems to just be expanding so quickly is because of these templates online, whether it's on Reddit or on even Etsy. Not sure, Felix, if you mentioned the Etsy one, but that was new
yeah.
to me. I guess that's a handmade good that you can get a tool book on how to file these claims. So we've got a lot of examples here of these repeat offenders. These are the frequent flyers, the names that keep popping up. Um, they have really manufactured a template on how to do this over and over against all different companies, and seems to be teaching other pro se plaintiffs to do the same thing as well. So it takes the TCPA, what was originally intended to be something that a consumer could use themselves, and it's turned into an abuse of that process. I personally think that there's more pro se litigants in this arena because it's a little bit less fact specific than, say, if there's a slip and fall at the grocery store. There's so many different types of fact patterns that could go into this where the TCPA presents a little bit more of a clear-cut case, whereas if the call occurred and can be proven, then here's up to this amount of damages. Um, Now, again, of course, the claimants usually omit or they seem to want to skip over actually having to prove where the calls came from, but we'll get to that. So you can see some of these examples here, and I'm going to let you reach these on your own if you want to get more information that really go into it. And you can tell that the court is starting to recognize these patterns. So that's what's important here. And that's what's really interesting to us as well. It's been around, it's finally been around long enough that the court is starting to recognize this and penalize it. Normally, pro se litigants enjoy an assumption that they should get some type of leniency from the court on procedural requirements so that they might not have to, dot all the exact same I's and cross all the exact same T's because they don't have a law license. And so the court would look on that with favor and be a little bit more lenient than they have in the past. But now, when the court can recognize this as a serial pro se litigant or claimant, the pendulum is starting to swing in the other direction, that the court has lost patience with this abusive process. And that would be, that would be a good thing for the debt relief industry, or at least try to tamp down some of the abuse of the TCPA claimants. All right. Okay, so this is more of what we're talking about now with the ghostwriting. That's a tricky ethical issue with attorneys because of what I explained. If the pro se litigant wants to enjoy the presumption of leniency from the court, but they're secretly being aided by an attorney that should not allow them to have that presumption of leniency, then that attorney is essentially making a misrepresentation to the court over who is behind these filings. Um, Unfortunately, I'm sure that there are, or we know that there are sources out there of licensed attorneys who are selling these templates. And that's a really slippery slope with an unauthorized practice of law. What state are these templates being used in? Is the attorney barred in that state? Are there any disciplinary actions? It just becomes a very slippery slope in an arena of the law that we just don't see everywhere else, the way that it's duplicated to the extent in the TCPA type litigation. So we cite to another case here that'd be really interesting if you're interested in going into more, really seeing how the court looks at this. Reading the language from the court, you can kind of assess the tone and the direction that this might be headed. So several plaintiffs' firms were actually sued for working as the ghostwriter, and they were found to be, engaging in these abusive litigation tactics. It's basically a copy and paste against whatever debt relief provider they can try to put on the hook for making these calls. So this really goes into how when there's a hidden attorney involvement, it can be very dangerous for whatever attorney is willing to put their name on that or to be behind the scenes and provide this covert type of help. All right. I think we're ready for the next one. Okay, this is one I actually have a case right now against this serial claimant, the Gonzalez claimant. Um, Gosh, one of my favorite highlights here, this is just to give you an example of how the court is beginning to react to these serial litigants, the frequent flyers, as we've been calling them. So this specific claimant, if you look down here at paragraph 8, the court says Gonzalez exemplifies this type of abuse. A notorious serial litigant has filed no fewer than 32 TCPA claims over just the past 3 years. So Felix referring to people who earn their living this way, this is a prime example of that. So in this specific case, a serial claimant had made their claims against ADT, the alarm company, and the alarm company came back and counterclaimed against the serial claimant. So this is reserved in rare circumstances where the original defendant, here ADT, turns around and makes a bunch of counterclaims against the original plaintiff. You don't see that quite as often, but because the pro se litigants and these manufactured claim mills have become so much more prevalent, there's finally built up enough history to really undermine the credibility of these serial plaintiffs and try to demonstrate to the court that this is just somebody throwing spaghetti at the wall until they can find what sticks. So you can read through this at your leisure. It's an interesting read. I would recommend.
And if I could just quickly add, so this what you see, these are counterclaims filed by ADT. And what is really fascinating here, what Rebecca mentioned, is that some of the companies are just look, they're hiring investigators, they're doing a lot of their own research and due diligence on these serial plaintiffs, and they're fighting back, right? They're basically saying we've had enough, and we, we've highlighted here again. These are just mere counterclaims, but I think it would be interesting to see that a company like ADT, which is a national company, it's been around for decades. It's almost like a household name when it comes to home security. Would go as far as name other individuals, in paragraph 11 here, right? Again, these are just allegations made by ADT, but they go as far as to saying, look, we think there's a lot more going on here than just merely, the plaintiff. There's a whole organization of, individuals with whom she shares what they allege is business affiliation addresses.
And I will comment as well that, I just checked the filings in this particular case recently, and the plaintiff has now filed a motion to dismiss these counterclaims. So, of course, the plaintiff objects to this, does not accept it to be true, and the litigation, and this issue is still pending. So, it will be very interesting to see how this shakes out and what the court's final word is on this one. Okay. Now, here we've cited for you some of the different ethics opinions on how this ghostwriting is viewed in different jurisdictions. And as you can imagine, different states treat this differently, and also federal treatment of it and state to state treatment. So when you have state statutes like in Texas, like Felix mentioned, they recently enacted legislation that makes it easier for claimants to pursue these types of claims. Other states might follow suit, and then others are falling back. We're seeing a big division across, and it's as time goes by, we're going to be able to see what's happening state to state, and then hopefully we can provide some type of analysis, maybe even predict that claims are friendlier in certain states than others. Again, we provide this just as background only, not legal advice, of course, through the purposes of this seminar. But we want to give you the landscape of what's going on nationally, and it's really changing and shifting right now. So you can also see the disciplinary precedent where different courts have censured these attorneys under Rule 11, which governs a lot of our professional obligations and ethical responsibilities as attorneys. Because, like I mentioned earlier, if you're ghostwriting for a pro se plaintiff, you're essentially making a misrepresentation to the court about who's making these filings. And that's a big ethical problem. So that's starting to come through on the courts, and of course, we'll continue to keep you updated as that comes out and trends as we see them.
I want to just make a quick note that you see in the first bullet point, which is the ABA formal opinion, which allows undisclosed ghostwriting if not misleading. ABA formal opinions are not technically legal precedent. We just always point it out because it's the opinion of the American Bar Association. Yet you still have to look at the specific states. If you look at the New York County Lawyer's opinion 742, by the way, between 2011 and 2014, I was on the board of directors of the New York County Lawyers Association, which is at that point an association of 11,000 lawyers. The state of New York condemns undisclosed ghostwriting as deceptive. Because look, the courts, at least in the state where I'm licensed, we attorneys say bend over backwards for pro se filers. So, and over the years, I've seen outside of the debt relief space, I've seen in other attorneys who do ghostwriting who got sanctioned and even disbarred for doing ghostwriting in New York. And Florida and Colorado, just to give you kind of like a little different twist, it says, look, you can assist as a pro se plaintiff, but you have to disclose. So you can't just merely prepare legal documents and not disclose. That could also put, I'm not licensed in Colorado or Florida, but I imagine that you could get into some serious trouble if you're doing that. Why are we saying this to you? The reason that we say this to you is that to the extent that you are going to be dealing with pro se claimants in pre-litigation pro se claimants, these demands, you got to take a look at if it smells like, if it quacks like a duck, it walks like a duck, right? It's a duck, right? I'm sorry. Today's one of those days. you have to you might be able to use it for one of your potential defense strategies if you think that there's an attorney behind the scenes.
And also being aware of who's on the other side of your claim can be very helpful when you're formulating your strategy on how to go forward. I noticed just in broad strokes, if I'm dealing with a pro se litigant who's misapplying statutes, that's a dead giveaway to me that they're trying to use AI or some sort of online tool, maybe one of these handbooks or these forms that they've downloaded, but they're still trying to use it themselves versus when they start throwing out buzzwords that usually only attorneys use. Even things simple like vicarious liability, that usually doesn't come up in a conversational context of somebody who's not being aided by an attorney. Or if they're citing cases, that's usually some of these giveaways. So those little cues might help you know who's on the other side of your claim. And then leading to that, defense protocol. What can you do to really defend yourself against them? And really, in almost every case, the best defense is knowing what you have in your own records just as a starting off point. Understanding who the claimant is, having good records so that you can look and see if there were any contacts with that claimant. You can cross-check those phone numbers, see if any of their alleged timestamps line up with records that you have on your end. And ideally, maybe there was consent, in which case, if you got consent at the top of their list, that might invalidate the rest of the calls on their list too. So that can be really valuable records to have on your end. And also, if you have those internal DNC call list, that can be viewed favorably as well. As well as, of course, keeping a company from inadvertently calling someone on that do not call list. So if you've got those procedures in place on the front end, that can do a lot to help save headache on the back end, so to speak. Also, there's a lot of these automated systems. Although AI and some of these systems are being abused by claimants, they also are providing powerful tools for the debt relief companies themselves. So there's different types of softwares and systems that can help the company flag these serial claimants and maybe even pop up ways to prevent that from happening. So some next steps, say you get that demand in, it's good to go ahead and acknowledge it. We do find that when the pro se claimants feel ignored, it's good to keep them on ice sometimes. It's not necessarily your highest priority, but it's good to acknowledge it so that they know that you're listening, they have your attention, but make them back up what they're trying to say. Oftentimes on the phone with opposing counsel, or maybe just these last couple of weeks, giving me a typed up list of when you say a client called you is not any more valid than my child giving me a typed up list of the number of times Santa Claus called her. Just because it's been typed up doesn't mean that it's true, and we have to be able to prove each and every one, and the pro se claimants usually seem to overlook that fact. So requiring them to provide any call attribution evidence that they have, if it really can kind of slow down the claim or give them pause, maybe the reality check that they need, that they might not be able to prove everything that they're asking for. You also always want to ask for if there's any allegation of a do not call list violation, ask for that right off the bat too. Like Felix said at the beginning, since that's been around for a while, usually if they allege it, I find that claimants have it, but we always have to ask because sometimes they don't. So make sure you ask for that right away. We're trying to educate claimants that this $500 to $1,500 per call is not automatic. This is an up to $500 or $1,500. Specifically with the do not call list, it's up to $500. And I've personally seen cases where the court awarded $1 of awards per call to the number on the do not call list. So those damages are not automatic. It's good to educate the claimant on that, although oftentimes it's hard for them to get through to that. Again, as far as tone goes, I think that it's good, to stay in control, be firm with this, but also if you can kind of relate to them, try to be a little bit friendly and say, listen, we can't pay for calls that didn't make, and there's no proof that these calls were made. Sometimes that can keep the door a little bit more open for a reasonable claimant to understand their claim doesn't have the value that they thought it might have right off the bat. and want to come back down. Versus if you dig in your heels and really aggressive and shut them down or condescending to them right off the bat, that can usually anger them further and maybe even push them to be more of a thorn in your side than they might otherwise be. All right. Okay, so now the next question, what are you going to settle it for? Of course, they have their pie in the sky number because they read somewhere on a Reddit thread that, they're about to be a millionaire because of all these claims, because they had some missed calls on their phone. But maybe the reality comes in. Maybe you can only connect 1 to 2 calls to the client in this specific case with the actual evidence, with actual call attribution. And so then that has to be a business decision on behalf of the company. If this looks like a pro se litigant who's going to press, who's going to be difficult, who's going to file suit, who's going to engage in discovery, then you have to start evaluating, do you want to include a little bit of a cost of defense type of in addition to the nuisance value, what is it worth it to make it go away than having to deal with a claimant for the next few years? You don't want to be perceived as a soft target, somebody who gets an email and then the next day is opening their checkbook to write a check for calls that haven't even been proven that they've made. So this is really where it helps having somebody with a lot of experience dealing with these claims and these settlements to walk that tightrope of knowing how to stay engaged with the claimant, how to not alienate them or push them over the edge so far that now they've got an axe to grind and they just have a vendetta against you. So you want to be able to hear them and to be able to settle for a reasonable amount, um, but not become a target or not become, somebody that would be perceived as easy to go to or continue to be making claims against.
I also want to, the big $64,000 question is how do you make a decision to settle it or to, especially if they're alleging uh, that they will hire an attorney. And you have to look at every case differently and see if in fact the claim has any merit. But if the claim has no merit, right, you should not be, in my professional opinion, be immediately scared that they're going to run to a lawyer. Like what I mentioned before, some of these reputable attorneys who know what they're doing in this space will charge quite significant amount of fees, and some of them will want to litigate these cases for years. While of course it's going to cost you legal costs to defend these cases, at the same time you for the cases where you do feel that you did nothing wrong and it's nothing short of extortion, don't be afraid to say no and to litigate them. We're going to do another webinar. I was hoping to do it in December, but unfortunately with timing, it just didn't work out. We're going to do one in January is about some of the cases that have come out to be pro-defendant, right? Of course, it's not easy to dismiss a case on a motion to dismiss, and it's going to cost you attorney's fees, and that's not what I'm recommending. But I'm also in good conscience tell you that you shouldn't just open your wallet and pay to every person who sends you an email and attaches a bunch of screenshots. That also doesn't set a good precedent as well. So you'll have to figure out the balance. We're sort of running low on time, so I'll try to really, if it's okay with you, Rebecca,
Sure.
I'll try to just move on to the next slide because I want to try to wrap up. Um, so most importantly, if you do decide to settle, make sure it's a very broad release. And what I mean broad include everybody under the sun to make sure that you're protecting yourself, your affiliates, your vendors, and you also keep this confidential. Rebecca and I were talking about this yesterday. We have a case, and obviously we can't discuss, where we have an attorney who apparently has now his wife filed a pro se demand, and then this attorney recently personally signed a confidentiality agreement. So there's going to be a question of whether or not this attorney, in fact, breached his own confidentiality agreement by now bringing his wife into this. Yeah, so confidentiality is very important. Uh, of course, the most simple one and easy is just obviously make sure that you're compliant and you have all the proper consent management, express written consent, so you don't get yourself into the mess. Um, so look, obviously it's no surprise that do-it-yourself has been on the rise, and it's going to continue. My prediction, if we do another webinar next year, we're probably going to continue to see this. The only thing that would potentially change this trajectory would be if um, we're going to see more sanctions against one, attorneys who are ghostwriting it, and two, the bar associations and the bars, not the association, the bars going after these do-it-yourself websites. For instance, various states had no problem suing companies like LegalZoom when LegalZoom came into the scene about 2 decades ago by alleging it was an authorized practice of law, right? As we attorneys say, UPL. And so it would be interesting to see if at some point there's going to be enough pressure from the defense bar, from trade associations to encourage the bars to prosecute and take down these websites. There's nothing wrong to to provide for informational purposes of what your legal options are, what the law is, of course. But some of these Reddit forums and websites that I've come across, yeah, I don't think that would pass muster, at least in my state. The balance, of course, is to what at what point um, will the bar step up and go after these promoters of litigious behavior without any really ability to really without any legal reason to do so. Um, so I, I think that's pretty much what we have for us. Um, these are our email addresses, so you could send us emails if you have any other questions. Um, Rebecca, thank you. I appreciate you joining our first webinar. Um, Thank you for everybody joining, and hope to see you in Irvine at the end of January. We appreciate your time, and we'll be in touch. Thanks.
Thanks.